Good afternoon, it's Alex Woods, financial mis-selling litigator. Now this is a quick summary of a extremely significant case that was handed down by the Court of Appeal on the 16th of December last week. The bulk of that case I've gone into in some detail and analysed and discussed and aired the various issues that arise on the 30-minute video posting to your left. So this is just a headline summary to help those who simply want to dip into the judgment and understand what the principal findings of the Court of Appeal were. Okay, so essentially there has been for 2 years now hanging in the ether a landmark judgment called Harrison and Black Horse Court of Appeal judgment, in which it was established by the Court of Appeal, His Honour Lord Justice Tomlinson giving the leading judgment, that compliance with the strict technical wording of a lender's own insurance business of conduct rules created by the FCA, strict compliance with the rules was sufficient to protect it against an allegation of unfairness where a consumer is bringing a claim for missold payment protection insurance, for example, against a lender. And there was a massive commission in that case of 87%. Black Horse, the financing flunkies of the 21st century, once again excelling themselves by getting a case all the way up to the Court of Appeal. I can perhaps only assume that either they are just the most profligate financially most profligate mis-sellers in the land, or when all the bankers meet together in their club, poor old Black Horse picked the short straw whilst they were sipping on their cognacs and having coffee and laughing at, how they'd stripped the shirt off the backs of so many poor consumers over the past 2 decades. And they were sitting back smoking their Havanas, and poor old representative from Black Horse, Lloyd's subprime division of Lloyd's, picked the short straw and said, I'll be the one to deal with the legal side of things and try and protect and defend the bank's interest through the courts. A bank is a morally neutral animal, we all know that, and there's no point in pretending different. And you'll see that played out in this judgment, and I do urge you to have a look at the 30-minute video to my left, which does delve into the issues of the way that the bank works in terms of timing and organising strategically fighting litigation in order to maximise the possibility of getting the best judgment for itself. But here I think they have taken a step too far and shot themselves in the foot. So that was the principle set by Harrison and Black Horse 2 years ago by the same court that have delivered this judgment, Plevin and Paragon. Plevin and Paragon and Conlon and Black Horse, 2 co-joined appeals which essentially were probably co-joined for the purposes of inviting the courts to rule on the scope of the unfairness provisions in this rather exciting or depressing piece of legislation, depending upon which side of the fence you sit. And the judges in this court, in spite of the fact they dismissed one of the 2 appeals, expressed extreme, I don't think that's an exaggeration, extreme disappointment at the findings in relation to Harrison and Black Horse on this very issue. They felt that Conlon and Black Horse, one of the 2 conjoined cases, the appeal of which was dismissed, wasn't distinguishable from Harrison and Black Horse, where you had this 87% commission on a payment protection insurance policy. From this case, Mrs. Conlon, a nurse who only wanted £1,500 additional lending, consolidated old loans, and had a £3,500 payment protection insurance policy foisted on her, that the judge at first instance said, if she'd known about it, she wouldn't have entered into the transaction in the first place, and in which the judge had been faced with evidence, and the solicitors from the side of the consumer done an exceptionally good job here, of internal policy documents provided by, submitted, disclosed, filed, served by Black Horse, in which they had said to staff, managers and staff, whatever you do, don't tell the consumer about this payment protection insurance policy and the size of the commission that we're getting from it. because if you do, they'll probably go off and try and get it somewhere else, and that will damage our commercial interests. So a case that's quite distinguishable on its facts in many ways from Harrison and Black Horse, insofar as in that case the guy would have probably taken it anyway, and there were various other features of the case. Here there was clear unfairness, and yet the Black Horse had complied, and Paragon as well was strictly in compliance with the Insurance Code of Conduct of Business rule book, with the rules of their regulator, the FCA. They were in compliance. The ICOBs say you don't have to disclose a commission to a consumer. So it's a rather interesting judgment for lawyers, but it's also of substantial relevance to consumers and obviously to lenders, because now you can't just fall back on technical compliance with the rule book, and believe me, ICOBs is of biblical proportions in terms of laying down rules. It's like a dictionary in its size. That you can't just rely on those rules. And in Plevin and Paragon, once again, the broker had gone bye-bye, had folded, had gone into liquidation, and left the lender carrying the baby. And the question was the scope of the unfair relationships test wide enough such that it caught Paragon, even though they hadn't been involved in the dodginess in terms of the sale of the payment protection insurance policies to the consumer at the time. There the appeal was was upheld, and the consumer won, and Paragon, it was decided that Paragon was liable. So quite an important judgment. As I say, go into the 30-minute version for the details of the judgment and an analysis of the legal principles and the way in which the court arrived at the conclusions that it arrived at. But if I can just simply conclude by saying that two things. Firstly, in terms of the proceedings themselves, the Court of Appeal were very hopeful that the matter would go up to the Supreme Court in order that a judgment could be given for the purposes of clarifying the scope of the unfair relationships test and specifically challenging the legality of the Harrison and Black Horse decision about compliance with the rules is a defence against an allegation of unfairness. These Court of Appeal judges want the Supreme Court to clarify the issue because they're not satisfied with the decision of their own court in an earlier judgment. That's the first thing to be said. And in saying that, it's very unlikely that it is going to get up to the Supreme Court because, in the Harrison and Black Horse, an appeal was prevented to the Supreme Court in that case because Black Horse paid out a large sum of money and settled the claim, even though it actually won. In this case, where the judgment has gone against them, in substance, if not technically, at least in one of the two cases, it's very unlikely that Black Horse won't dig its hands as deeply into its pockets as required in order to make sure Mrs. Conlon doesn't go up to the Supreme Court and, second point, establish or further cement and solidify this concept of, as far as if you're a lender, vague and woolly concept of an actionable principle of fairness where it comes to financial institutions being accused of mis-selling in relation to financial products. So a pretty key judgment, and something that consumer credit, those on the side of the consumer, could take considerable heart from going into the new year 2014, and those on behalf who are working on behalf of the lenders, lawyers are going to have a great difficulty in advising their clients on how best to set up systems and businesses in the future to mitigate against the dangers of litigation. And it may mark something of a seismic sea change. I'm not sure you can mix metaphors relating to earthquakes and see it, well, I suppose you can. A tsunami is a seismic sea change. It's a tsunami type situation, arguably, in a subtle consumer credit way, because it may be that the way to run a proper financial institution, proper lending business, retail certainly, where you're lending money to consumers, is to embody a proper set of principles and ethics that govern the way that you operate as a business, and not just say, well, we've ticked all the boxes, so it don't matter if we're a bit dodgy. Thank you very much for your time, and I look forward to posting to you in the new year. And another bit of good news for me personally is the Solicitors Regulation Authority on Friday advised me of their intention to grant me authorisation in the new year, in January, in the new year. Many thanks, and look forward to posting once more to you, and many more times to you then. Goodbye for now.